opening our hearts and listening to others, we can see that families go beyond that. So thank you very much.
Thank you.
Hi, I'm Allison Hood. This is my partner, John Tabor, and our daughter, Elliot Tabor Hood. We live at 129 West Lincoln Avenue in Gettysburg. As we examine changing the definition of a family unit for a single-family home, it is imperative we consider a multitude of unique family units within Gettysburg and beyond. The term household or housekeeping unit emphasizes the shared living space and responsibilities of the group, not necessarily their familial ties. We should not penalize folks with unique family configurations, but rather welcome the diverse structures that make each family extraordinary, and Gettysburg a more diverse, inclusive, and welcoming place to live. I support expanding the definition of a family unit to include any number of individuals, related or not, living together as a single housekeeping unit, which is inclusive and builds upon these values that encourage us to explore the meaning of family beyond the binary. Family structures can be single-parent households, multi-generational households, blended families, chosen families, LGBTQ+ and polyamorous families, and families formed through adoption or foster care. Family is not defined by a single structure, but by the presence of mutual care, respect, and commitment to one another's well-being. Want to share? Right there. Is it down? Yep, right there. Yeah, right there.
I think a family is a loving group of people who love and accept each other just how they are.
Thank you. Hello, I'm John. I would absolutely like to reiterate what Jamie said and what Darren said. I couldn't have said it better. I want to add, I understand the need to keep single-family housing separate from student housing. But there are a lot of different ways to handle that without changing a family definition. One thing I think Lauren Jean's going to bring up is a licensing program for student housing. It's well established in College Station, PA. It seems to work well. And that would apply to, fraternities, sororities, student housing like the one on Broadway. I'm at 129 West Lincoln. They're right in my backyard, so I got you. One thing separate from that I wanted to bring up that also contributes to our current lack of affordable housing is the prevalence of dedicated Airbnbs, where people will come in, or companies will come and scoop up houses with the sole purpose of using them for short-term rentals. My thought is that allowing homestays throughout the borough with some common sense guidelines, like requiring proof of a primary residence, will discourage quick flipping short-term rental properties by increasing competition. If there are more available Airbnbs, there's less of an incentive to buy single-purpose Airbnb properties. Additionally, it would allow more family units to explore alternative avenues of income while bringing additional tourists and money into the borough throughout the year. This could provide lower-income families an option of owning their own home, knowing they have an additional built-in source of income within the property. Yeah.
Thank you. Thank you. Elliot in particular, thank you. Others?
Hello, I'm Lauren Jean Griffune. I live at 126 East Middle Street. I've been living in Gettysburg since mid-pandemic, which is actually a surprisingly great place to land and meet people even when you're on lockdown and getting to meet people just on the street. I live with my 2 children. I've housed women running from domestic violence situations. I realize in my neighborhood, I don't think we're in the single-family occupancy, but I think that anyone should be able to house women and children of any number who need to leave a bad situation. And I've also worked a lot with young people aging out of foster care, ending up at SCAP, trying to get a place to live, but they don't drive because the judge doesn't let them drive when they're 16, and then they end up in housing units outside of Gettysburg with no vehicle, small children, and I'm driving them around everywhere, and our friends, our community are driving them around everywhere. So I would love to see more flexibility in housing availability, not less, for people like that. I would love to see those young people be able to access Gettysburg and walk to the market and access the things that more wealthy people do. One of the things I just wanted to say is that my suggestion for a definition of a family would be one that is used in Hartford, Connecticut. A group of persons living together as a single housekeeping unit, regardless of their relationship by blood, marriage, civil union, or adoption. And I did want to bring up the regulations that they're using in State College for their 2029 zoning regulations, but they voted on it in like 2015. And it basically states that you do need a student home license. And I would assume in that process, if there are lots of problems with your property, that you would lose that license. But in this case, when they define what a family is, they say, and if you have the student situation, you need to have the student license. They're limiting it, and these are some options, but I absolutely think we need to be very thoughtful about what a family is. I've gone through some transitions in my life, and my family, to me, is different than just my children and I, and my partner. It's the community, the people who come and help me, and I think we all should be able to have open doors to anybody who needs space in our home, and we should choose who's there. So, thank you very much.
Thank you. I think, I think someone, Sue, were you next? Okay.
Good evening. My name is Paul Kellett. I reside at 46 Middle Creek Road, Fairfield, but I own quite a number of properties in the borough. I've been a landlord for over 20 years. I was here when this was first adopted with 4 people, and I spoke out then. I'm very concerned about how you define 4 people, whether it's a wife and 2 children and a boyfriend. Is that now 4 unrelated people? And it is a definitional problem, but also the enforcement of this is you're putting a definition on the problem that you're not trying to solve. The problem you're trying to solve is disruptive neighbors. Let's go after disruptive neighbors. Let's not go. And I can tell you, in my 25 plus years as a landlord, my most disruptive tenant was a single woman. And the neighbor called me every morning at 2 a.m. and said, if I'm woken up, you're woken up. And I can tell you that the process to solve this problem that you want to get at as a landlord, you don't have a right to say they're out of there right away. The borough cannot do that. I have to give 15 days notice, get a hearing in, it seems like 15 days. The law says 9 to 10, but I always get them in 15. So that's 30 days. Then after the hearing, they have 11 days to appeal, 41 days. At that point, I can go in and file again, and in 15 days, they'll put them out. So you have 2 months of the same problem. And you're also making a landlord enforce a rule that isn't there. And also, the landlords often don't lease to 4 unrelated people or even 4 people. The tenants often will sublet or move other people in. And so you're not really solving the problem, because if you ask me how many people I'm renting to, I'm going to say these are the names on the lease. And on this problem, my understanding is these kids have another address. So the students have, if they have another address, they're not really living there. They can say, I don't live here. And I get that all the time. I'm saying, hey, you can't have this many people here. Oh, he's just visiting. So you have to prove this. I have to prove it. So you're going to make me become a genealogy expert to figure out if that's really their cousin? Think about the onus you're putting on a landlord by doing this instead of going after the parties. Everybody knows what a party is, but how many people can really define cousin or stepchild or anything else. You know, can you really go through all that paperwork? And should a landlord have to go through all that paperwork? And should the landlord be paying for an eviction process, which probably is going to end after graduation, and you're not going to solve the problem? You know, when you have a 60-day process, that's usually, they start 65 days before the semester ends, and they say, yeah, evict us. So I don't really think you're getting at the problem here. And you can strengthen up noise ordinances, party ordinances, how many people can be allowed there. But you can have as big a party in the same house with 2 people as you can with 4 people as you can have with 6 people. It's just simple arithmetic. How many beers do you have and how much floor space do you have? It's not going to change. The party isn't going to change based on the number of habitants. And so you're going after the wrong thing here. You should be going after parties and misbehavior, not going after families. And you're going to catch a lot of bycatch, as they call it. You're going to catch dolphins with these tunas. And it's not fair. It's unfair to the landlords. It's unfair to the people who have to live in fear because, hey, my cousin needs a place to stay for a few days. Does that put me in violation of my lease? So you have to really think about what you're trying to get at and don't go after something that you don't want, which is definition of family. You don't want to be in that business. You don't want to be in the definition of unrelated. You want to regulate parties. Regulate parties. Thank you.
Thank you. Are there any others that would like to speak to items on the agenda?
Bob Kermick, 125 West Broadway. And saying like many, I'm very sympathetic to what we heard about the definitions of family here, but I think we all agree Gettysburg's a welcoming and nurturing community but my suggestion also is that if you're raising your family, which we certainly welcome, that if you start getting the new pseudo-frats on either side of you and surrounding you on the street, it's not going to be the kind of place you really thought of to raise a family, would it? Which is what I'm bringing up to council, is that's the issue here. And I remind you, actually something Nick said at the last meeting, I didn't get a chance, but you said that the frats were sort of analogous to the bars and the retail districts. I said, not really, because you're talking about the difference between professionals and amateurs. That if you go to a bar, they cut you off and you've got a set time, and you know when you move into that neighborhood, if Gettysburg grows, we're hoping to get more bars, more restaurants in town. Whereas the frats were set. You couldn't have any more. And now you're looking at the pseudo-frats that are moving in, which is our great concern. And I hope you will consider this so that we don't see these proliferate. And I'll remind you something else. When we moved in, campus security used to be, you'd call them, and they would shut down the frats if the parties were getting too loud. They don't do that anymore. They pass you on to the Gettysburg police. So, frankly, our cops have better things to do than sit in front of the frat houses at 2 or 3 o'clock on a Saturday morning trying to shepherd the students off the street. And you're adding to the workload of our Gettysburg police, and to a certain extent zoning, because they're now being called in more and more because of the garbage issues. And we limited the number of frats, and I'm asking you, and I hope we can come up with a compromise, because, as I said, I don't think the people who have families that might not meet the 100-year-old definition of family are in that same position, that they don't want to see Gettysburg become a series of party houses and homes owned by LLCs with a group of students living in them. Thank you.
Thank you. Given that it's been almost 30 minutes, we could take 1 or 2 final comments and public comment at this moment. Okay, thanks.
I'm Sue Sipperly. I live at 314 North Stratton Street, and I'm actually in the R2 district, but have similar issues going on. And as Bob mentioned, pseudo fraternities I live across from one, and for the last 3 years, 4 people rent it, but especially on the weekends, you've got any number of people and noise and drinking, and they're not the worst ones. But what I've been concentrating on is the residential office zone that's currently on Carlisle between Water Street and Lincoln Avenue. And the draft has decided to remove that and make it R2. And right now, that contains college-owned housing, office uses, and several others that are listed in the residential office district. Plus, in the purpose, it says there's opportunities for conversion of large buildings to something else. And it lists all kinds of things, like small restaurants and things like that, that it would be nice to have available in our end of town. So it nicely contains those sort of college-oriented uses adjacent to a residential neighborhood. There's kind of a dividing line that it seems to work. So I don't know what the thinking was to remove that. But I also asked the college residence office, because there's been a lot of rumors about students being required to live on campus, and the residence director said, officially, all students must live on campus for 4 years. We do have a process that allows for a small number of seniors to be released from this requirement and live off campus. And this trend has been going down. But she said, obviously, somebody can pay to live on campus, but also pay for a house off campus, which is basically, especially these frat things, pseudo-frats, I like that term. So the way it is currently has been working pretty well, because there's kind of a divide between sort of these more populated houses, because they're bigger, and there's opportunities for people to do things, even a bed and breakfast or something like that. So I'd appreciate it if you would keep it as those uses, and even if you want to call it something else, but it's working, so I'd like to keep it that way. Thanks.
So we've had many residents speak on the topic of the definition of family, and then one resident speak on a zoning map issue related to a section of the borough. Are there any comments unrelated to those, something new that we haven't heard that you want to speak now at the beginning of the meeting? Okay, then, oh, I'm sorry. Yeah, Mr. Bergner.
I'm Michael Berkner. I live at 66 East Broadway, and I want to first off thank the members of this board for your service. This is a tangled and difficult matter that you're dealing with, and you really need the wisdom of Solomon to get where you need to go with this, and I think most of us appreciate that. I just wanted to make a couple of quick comments that play off of some things that have been said, and I first off want to say that sitting in the audience, I'm as impressed as I think you are by the thoughtfulness of what's been presented to you from each of the parties who've spoken. I think we have to disentangle some things here. It would be definitely unwise to have a policy that was not helpful to people who do not live in the traditional nuclear family. I think that's a no-brainer for you. I think the problem that many residents see is that there is a growing tendency here for wealthy parents of college students to purchase homes that become what has been described, I think, by Mr. Crumrich accurately as pseudo-fraternities. And I might correct Darren Glass, whose wonderful presentation I appreciated very much. It is not just one street on West Broadway. It is apparently about to happen on the east block of Broadway as well. And this is a function of the college having a see no evil attitude about what has been going on in the last couple of years. And specifically, to pick up on what Ms. Sipperly had to say, the college does have a policy requiring freshman students to live on campus. And yes, the college, because it is shrinking, has been telling people, well, there will be fewer students living in the community, and that is very likely true. But the college is completely uninterested in the concerns of the residents. When a family, a parent, purchases a home in a neighborhood that has been highly functional, and as has been described here, neighborly in the best ways, whatever the nature of the family that's involved, right? Whatever their definition of that family, into something that is different. So we have 3 places now on Broadway, and we have apparently 1 or 2 on Stratton, and also traditionally also on parts of Lincoln near the Stratton Street row houses. It seems very likely, given the college's financial situation, I'm not saying the college is going down the tubes, but they do not want to chase away wealthy families who can pay much or all of the freight of the tuition of their kids by saying to the parents, your son really does need, or your daughter really does need to live on campus. So what they're going to do, and I've written to the residential director at the college about this, and it was very clear from her response that they are not interested in enforcing anything. So here's what I leave you with. I do think you've heard some very powerful testimony about not wanting to be rigid in the way that you describe and define a family when you're doing this zoning work. But I think that the concern that we should be having right now is what kind of community are we going to have? What kind of neighborhoods are we going to have? What kind of peacefulness are we going to have? And I think that something along the line of the planning board and the council finding ways to assure that you're going to have good neighbors, peaceful neighbors, fewer disruptions, fewer needs to call the Gettysburg police. And I think you can do it, but I'll close with my belief that you're going to have to be Solomonic in doing it. Good luck.
Thank you very much. That might be a good way to segue into our first item. Oh, okay, one more, please. Yes, one more.
It's not related to student housing. Hold on. Bolt, did you want to come here? Tell them your name and where you live. You have to stand in front of here.
My name is Bolt, and I live on East Middle. And I used to live on a farm, and now then I moved away to Arizona, and then I moved here, and I really miss chickens, so I really want chickens to be legal. I really want chickens to be legal here. And some people say chickens are noisy, but motorcycles are way louder. So chickens sleep at night though, because some people say that chickens are noisy at night, but they sleep at night. And motorcycles don't. and so yeah, I want chickens or chicks.
Thank you, Bolt. Thank you very much. And thank you all. We now turn to the deliberation, and given that robust public comment, we will keep the deliberation to the Planning Commission, who has to make this Solomonic decision, or at least recommendation. The Borough Council makes the decision. John Whitmore has provided some language, and he has 5 options, and so now we move to this discussion that you all just spoke to, related to the definition of family. And I believe it was last Tuesday or Wednesday, John. You put it on the website on Wednesday, I believe?
This was included with the meeting packet on Friday.
Oh, on Friday, okay. So on Friday, the Planning Commission and the public were able to access the options which we might choose from if we go down the road of revising the definition of family. Of course, we don't have to, but these are options that he created. So, John, if I could ask you to, if you don't mind, and I'm putting you on the spot, could you read the definition that is existing first, which
Yeah.
I believe is your first item, so that those in the room know that there is existing language that defines family? It's in the ordinance, and it is enforced or not enforced or whatever, but it's there. And that any change that we make would be to this language, and we have at least 5 options in front of us that this commission has seen and that the public was available to see on Friday.
So the current definition applies to, it is enforced. So it's a household consisting of one or more persons related by genetics, adoption, or marriage, or a group of 4 or fewer persons who are not related by genetics, adoption, or marriage, and none of whom are wards of the court unless such wards are related by genetics, adoption, or marriage to members of such group living in a dwelling unit. Family home shall include state licensed adult family home, state licensed foster family home, group care facilities, and group care homes for the disabled required to be accommodated as residential uses pursuant to the Fair Housing Act. The term family shall exclude individuals residing in halfway houses, group homes licensed for juvenile offenders, or other facilities, whether or not licensed by the state, where individuals are incarcerated or otherwise required to reside pursuant to court order under the supervision of paid staff and personnel.
Thank you, John. And now you have these 5 options, and I would ask, unless there's an objection, that you don't need to go through each item of these because they are complex. But if you could speak in very general or very, paraphrasing of what the 5 options are, maybe where they came from.
Yeah.
The commission, I believe, we'll see, has read them. The community's had them, so we're maybe going to forward one of these tonight. But if you could give us just an overview of the 5.
So, beginning with A, this was a definition I previously helped craft for the city of Morgantown, West Virginia, which was experiencing the very same problem that I believe has been expressed tonight, making sure that we're representative of all family types that are in existence, could be in existence, and would be beneficial to single-family dwellings. The problem is trying to get to the finite point. So this is a very complex definition. It also could be challengeable. The next one, B, this is a modification of the existing ordinance. It really tries to thread the needle by, getting into a better definition for the seasonal nature of college students. Section C, this is from Philadelphia, Pennsylvania. Very short, a person living independently or a group of persons living as a single household unit using housekeeping facilities in common, but not to include more than 3 persons who are unrelated by blood, marriage, adoption, or foster care status, or are not life partners. D, this is the U.S. Department of Housing and Urban Development's definition for family. This would be compliant language, at least from staff's determination, to be in the right with the Fair Housing Act, which that's generally where our complaints would most likely come from if we are challenged. In this definition, we've also included some language to limit the availability of multiple college students living in one dwelling unit. Finally, there's E. This is from State College. It's defining family as an unlimited number of persons related by blood within and including the degree of first cousin, marriage, or adoption, including foster children living together in a dwelling unit, but not including a living arrangement otherwise defined in the chapter as a student home. Other persons not included in the foregoing definitions are called unrelated persons. That kind of feeds into the final definition that I included. This would actually get to the crux of the student housing issue. Creating a new class for student housing. This would be group So this is a form of student housing which 3 or more students of Gettysburg College or other college or university are legally allowed to provide degrees to persons or a combination of college or universities reside. This form of student housing includes detached single-family dwellings, two-family dwellings, apartments, townhomes, or multifamily dwellings. This one, I can imagine we would probably have conversations about the ability for it to be challenged. As zoning exists, zoning is a way to discriminate what can happen on the land. So there is always the very real risk when we change this language that we would be opening up the borough to litigation. Even if all the intent is great, it still has to pass the muster of our Fair Housing Act. As such, staff isn't really in favor of anyone in particular. We have heard there was a comment tonight about the definition D. That one would be something I think would be a good starting point. It would allow for compliance with with our federal laws, and if additional language to tighten that up even further, we could have a discussion then with the solicitor.
So I'm going to ask one question and then see how planning wants to ask questions about them or move on one or more, on one of them, maybe starting with D. If we went with, let's say, D, would we actually need to have that student housing language? Because D would take care of things perhaps enough that we don't have to specify student housing. Could you foresee us not needing to do that student housing definition?
I'm more inclined to punt this over to the borough, the solicitor in this case. If Adam.
Well, so I'm not going to weigh in favor of any particular one of these because I'm not sure that that's really my role here. I didn't write any of these. And these are not your only options. I mean, you can do really a whole lot more than this. One place you might want to think of in terms of similar demographics and size college and slightly larger town might be Carlisle. That came to mind as we were going through this. I don't know what their definition might be of anything. I think you have to keep in mind what your goal is with this. Are you trying to achieve a goal and then reach that goal by defining family in a certain way? Or are you defining family in a certain way and therefore going from there? I mean, it's almost a chicken and egg situation. I would also be cognizant of the fact that you have various zones that you are going to be creating. So if you're trying to preclude or prevent student housing from being in certain areas, I don't know that defining family is necessarily the best way to do that.
I understand that. I just am trying to think back on the last two meetings where we were trying to figure out the concept of is student dwelling, is student housing its own thing, and should it be clarified? But when I read these 4 or 5 suggestions, it occurred to me that perhaps we do not have to do that, that some of the concerns are built into these definitions.
One thing I would say, and then I think I'll stop, is regardless of what definition you use, whether that's the current one or one of these or something else, you want to have one that, number one, is enforceable. And I mean that enforceable under the law and enforceable by staff, that they actually can determine some of these factors to the extent there's anything to be determined. I think that was the point that one of the speakers at the podium was making. How do we ascertain related status, perhaps? And secondly, you want your definition to be understood by the general public. I would suggest some of these are rather dense for someone to read through, and if we need to have them be summarized because we don't understand them as a group, it's probably not a good indicator that the general public's going to understand them.
Okay, thank you.
And I don't mean any offense by that to anyone, but I think it's important that people know what you're trying to achieve via these definitions.
Well, can we begin with now asking questions, but also keeping in mind that our planning director just mentioned item D as a potential starting place, but let's go wherever, Sarah.
I just wanted to ask if your question was that do we even need to define student housing if, right, so, and I had the same thought at first also, but it seems like if our ordinance is going to allow student housing in some places and not others, so it'll be permitted in certain districts, then it would have to be defined in some way.
Yes. Agreed.
Okay. Well, let's start with the question about family. We have a definition. We have some suggestions for alternative language. And what does the Planning Commission think?
Wait, start, Charles. Me personally, I think two things. You know, this has been the definition for a while. There hasn't been any issues. It seems like recently, one of the reasons why this has been brought up is because of these, I also like the term pseudo-fraternities, we'll call them that, let's say. I don't know, for me personally, that changing the definition of family would address this. I think, I'm sorry, sir, I forgot your name. But Paul's point about, you know, you can have two students renting a house anywhere. I live in R1 as well, and they can throw a party. And I think that's what is disruptive to the community, right, is loud parties. To me, it doesn't make sense. Does it matter if there's two students living there and they throw a party, they have people acting inappropriately outside their house, or there are four students technically living there and they throw a party and they have people acting inappropriately outside of their household? And so, to me, the definition of family has been working in this town for a while. I would personally not be in favor of changing that. I think, are there other things we can do as a commission to regulate these kind of pseudo-fraternities? I don't know the answer to that. I know when we talked about early on in the committee that met about zoning initially, we talked a lot about kind of private equity buying homes in the town and then renting them for a profit. Everyone rents for a profit, but, like just really charging the most they can, buying up homes and, not being owned by individual members of the community, rather being owned by people outside of the community and companies. And unfortunately, we are not allowed to determine who can and can't purchase a home, right? I think if there's a worry on different neighborhoods about what these homes are going to be turned into, I think the responsibility is on the current homeowner when they sell the home, right? You know who you're selling a home to. You can decide to sell your home to the highest bid, which would likely be a private equity or a private company that's going to then rent that, or you can sell it to, a family that's going to live in that community. And I think it's challenging for the Planning Commission to regulate around that, because legally we can't regulate who can and can't purchase homes. So I don't see family being a part of the conversation around zoning. I think if there are other things around noise ordinances and things like that we can do to address some of the issues that people are having with some types of these housing, I would be in favor of that. But personally, I don't see a need to change the definition, certainly not limit the definition of family. And then I think the student housing conversation is a separate conversation. To Sarah's point, family is defined everywhere where single-family homes are allowed. Student housing is particularly allowed or not allowed in certain zones on this map, and so I would say we tackle them separately.
Okay. Others?
I just wanted to thank John for providing all these different options, and I think it brings to light the complexity of this issue. And when you read something and reading that the existing definition, knowing that it probably hasn't been enforced, but I think the risk is to me that it gives the ability for someone to ask the borough to enforce it. So when I read these definitions, the one that to me was most attractive was D, was the HUD definition. It did seem to me the most inclusive and also addressed the issue of student housing. So that's the one that I would think we should change to.
Thank you, Sarah.
Quick thought. I would assume that a HUD definition is not going to run afoul of the Fair Housing Act. But I also, in that same line, would assume, without getting political, that the definition put forth by HUD may be changing as a result of political occurrence. So
I assume that's, if I could just respond, that we could still adopt this and
Absolutely.
not attach it to any ongoing.
Oh, my word, no, you wouldn't do
okay.
that. No,
Yeah,
that
okay.
was
And
not my point.
Okay.
Not my point.
Since we're going down the line, I want to share that I was pleased to see D I think that it is actually more inclusive in some regard than the current definition, and yet also handles the concern that some have brought forth. So I think D should be what we move forward with, and then Borough Council can weigh some other matters related to it, but I would agree with Sarah. John or Marty? Or Jen?
Yeah, I don't think that family should be defined. You know, I think that we want to, as Mr. Glass pointed to, and also Ms. Bautista, we want to avoid any unintended consequences of potentially discriminating against people or leaving way for discrimination in a way that may not have been intended, but with changes that we're seeing, you know, in vulnerable populations. So I don't think we should define family, and I echo Nick's remarks that student housing is a separate thing, and we can't, I'm not in favor of regulating it in one area and then it's okay in another. Then we have problems of equity within the borough.
Thank you. Thank you, Jenny. John or Marty?
Well, I was not of a stable opinion about the definition of a family, but I am impressed by the comments that were made earlier tonight about narrowing down the definition of what a family is, and I think that it's convincing that it should be as open as possible. I'm not sure that I agree that it should be just any group of people living together by choice, and I think that's a dangerous definition perhaps, but I'm also convinced by the comment that was made by Mr. Kellett about be sure you know what you're asking for and what you're trying to accomplish, and defining family is probably not the way that we get rid of the pseudo fraternities, and I liked it when Bob came up with that, but I think that it's possible to define a college student, and I think that that might be an avenue to how we direct the planning, and I think actually definition D tries to do that with the definition of a college student, but I am basically in favor of keeping an open definition for family and trying to focus on ways that we can limit the disruptions that occur when you have 1, 2, 3, 4, 10 college students living in a house that's made for entertainment, and I think that that's got to be our goal.
So if I understand you, John, and then I'll repeat back here, I understand you saying let's eliminate the definition altogether for family?
I'm kind of open on that right now, Charles.
Okay,
But
all right. I don't want to, because that's what I heard Jenny, I think, say, and Nick say the current definition, perhaps?
Well, to be clear, I'm fine with also eliminating it. I just, for me, it seemed like we were making an issue that was okay, but if the council wants to move in that way, I'm fine with either D or with elimination.
Oh, so you're potentially okay with D?
Sure. I mean, I'm not to decide.
I mean,
Personally,
at some point, we have to come to like a
Right.
consensus
And
or a vote, so that's what I'm trying to figure out before we put all the attention on Marty Jolin.
And before we turn the spotlight there, just for the benefit of the commission, I can't say I know what this draft provides in this regard, but generally, zoning ordinances will say any term that's not defined has its either common definition, or it'll literally refer to, X edition of Merriam-Webster.
Which could be more exclusionary. Yeah. Okay, so Marty, what do you think about option D, about family leaving it open, or the current ordinance?
Well, I'm not qualified, I'd say, to give a definition of family, so I'm not going to go down that rabbit hole, but I am more interested in how do we potentially protect from housing, protect our housing from students coming into the area. So I would support our planning director in any way he can provide language that would be enforceable and not open us up to litigation at the same time. But in terms of the family, I am open to a more inclusive definition.
Okay. Not sure how to give direction to John based upon that, though, Marty. Would you say that there is one of these that is more inclusive in the definition of family, or are you still wanting to work on it further or eliminate it altogether?
Well, I'm leaning towards D, I suppose. It seems like everybody likes D.
So it sounds to me, unless someone wants to raise an objection, that there is more or less consensus around giving you the direction of option D. Okay, and we'll see what comes next as we put it into the final draft, and of course what Borough Council says. So thank you all for those of you who participated in that deliberation and discussion, and please stay tuned for what's next. What is next is something just as exciting, building height in the Borough of Gettysburg. We've talked about this not just for months, but for years. We did bring this up at a meeting 2 months ago. At that meeting, Nick Redmond was unable to engage the topic, and we had some audiovisual issues with Sarah Kipp participating. But John, would you bring us up to speed on what we're going to decide here for height?
So with regards to extended building height criteria, staff has made some changes to the ordinance language, and this is something we've gone over quite a bit. It only affects 4 parcels. The ability to have the extended height would be contingent upon meeting 3 provisions now as opposed to just 1. And so some of those provisions, or did I just have it? Oh. There it is. So those would be things like integrated parking, transit services, the Gettysburg Inner Loop, green area, green space, inclusionary housing. So the developer would have to provide multiple of those incentives to be able to be, or multiple of those exactions to be able to have the building height incentive. The building height itself, the proposal as it is the revitalization zone has a 48-foot standard. Buildings would be able to go up to a maximum of 72 feet with that building height incentive, increased height incentive. The properties in question, many of them, well, 3 of them are associated with Gettysburg Station. That project has, with the existing ordinance, a vested right to 72 feet for the building and an additional 12 feet for mechanicals. Just keeping in mind the existing right to that building height.
Okay, thank you. And so this is an opportunity for additional comment on that and any potential changes to that language. Does any planning commission member want to speak on this?
John, can you explain, I wasn't clear, because the way I've been trying to find this in the ordinance is by Googling, for searching for extended height. And it says the extended height building is only applicable to any R-zone parcel located east of Carlisle. So that's correct. But you said it was 4 parcels, because when you look at the proposed map, the R district seems to be larger than 4 parcels. So how are you where else are you limiting it besides?
So it affects. The proposal would only affect this parcel. Here's the transit center, here's the empty one, and then this one here.
Okay. So my thoughts about this are that, and I was on the task force that proposed the change to our limitations for height for that area when it did happen. And my recollection of that effort was that our purpose was to make that site attractive to a developer. And it was really about that parcel having sat vacant for a long time, and us desiring as a borough to have it put to more productive use. And I had a hard time with the proposal to increase the height there, but that was decided by the Borough Council. And as you said, the developer who currently owns the property and is apparently going to propose something at some point soon is actually working under the previous ordinance. So this wouldn't apply to him the way that's written currently. And I actually wish it was, because the incentives, as we've been calling them in this ordinance, have inclusionary zoning, which we didn't previously, unfortunately. I don't think it references the transit center anymore. So there's some issues I had with the previous trade-offs for that height that do not exist in this ordinance, or the proposed language anyways. But however, at the time that we did make that recommendation, I was opposed to what I saw as a very dramatic change to the permitted height in the borough and what that would do to our historic charm and our small town character. And I still see because the current developer already has the property and is working under the previous ordinance, I don't see any reason why we would have any language to allow extended height. The neighboring zoning districts are 45 or 48 feet. I'm guessing most of the buildings in those districts are probably 35 or somewhere between 35 and 40 feet. So to me, 45 to 48 feet already allows for some growth, increased density, extended height. And I think going above that would be detrimental to the character we have in those neighboring communities and just to Gettysburg in general.
Thank you, Sarah. Would others like to address that? So I hear Sarah saying existing height, which is 48 feet.
Charles.
Go ahead, John.
Sarah, I just had a question for you, though. When you say that the proposed developer has older restrictions than what we're talking about here, what restriction did he have? Because we've said the 72-foot allowance applies to him if they do the incentivized additions to the plan.
Right. So my understanding is that he will move forward with that, and he is permitted to build up to 72 feet with the 12-foot mechanicals. So in my opinion, there's no motivation anymore to include that height because he's doing it. We've accomplished that goal of having that property purchased and redeveloped into some way that's hopefully more productive than what it is now. And so this ordinance doesn't need to address these parcels because he's allowed to propose anything that in the previous one. Is that,
well,
yeah.
If that's true, and I think it is, it means that the developer will have a chance to exercise limits of 72 feet plus 12 feet, I guess, in that project, but we wouldn't necessarily be agreeing to having that enforced for any other projects. Is that your understanding?
Correct. Yep.
I can live with that.
Okay, so Sarah and John have weighed in on that topic. How about the rest of the commission?
If I may just add one point real quick. One thing to keep in mind, staff is recommending this. The height has been approved already for the Gettysburg Station project. The proposal that's being presented by staff is from the basis that it's not related to that development. It's related to that land. That land should have the ability to go up higher regardless of the development project, because in the wisdom of previous councils and previous actions, there's been a decision that this project should already have the ability to have that height. That's created a situation that's kind of untenable without having it apply or be permittable for other developers. So not just that individual, if that makes sense.
I think it makes sense until you said untenable, because it would not change anything about the reality of this project. It would change other projects.
Well, that's the thing, though. Staff is saying that this doesn't run with just that project. It runs with the land.
Okay, thanks. Thank you.
Yeah, and I guess the other reason that I recognize that, and I see the reasoning behind that, I guess one reason that I'm advocating for this more maybe extreme position of just striking the extended height altogether from the ordinance is that since I've been on the Planning Commission, it seems like we are fairly receptive to proposals from property owners to change the map of the zoning code to change them from what they're zoned as to a neighboring district. And so I'm imagining that at some point down the road, perhaps, what if the entire industrial district says we want to be in the revitalization zone, and then everything east of Carlisle has this allowance? That would be a huge swath of land that would then have this ability. So that's what one of my, probably unrealistic fear is, that just by simple map amendments, we could expand that district to something much larger, even though it's currently only those 4 parcels.
And I guess I'd share that because the name of this district, it's now going to be called the R District?
No.
REV. Revitalization.
Yes. So that is suggesting to potential developers that places in the borough that need to be revitalized should be revitalized through an incentive initiative that allows 72 feet. And I think I agree with Sarah's logic that that's not something that seems either practical or beneficial in my mind. So I would agree with John and Sarah that the height of our community is at 48 feet, and that it would be a very rare and radical occasion to change that in the interest of revitalization. But others?
So I walked into Adams County National Bank to talk about my mortgage, and so I had to take a seat. And on the wall they had Gettysburg, and the biggest photo of the hotel is right in the center. And I think most of you are transplants, but that is not a historic building by any means. Maybe 10 years down the road, Gettysburg might be this new development, and we'll be proud of it. I think I'm pretty proud of the hotel. I think it does its function, and it's a nice part of our community. So things can change, and often when they do, people grow to like them. So I think people should just keep an open mind to that. I wish the best of luck to this developer.
Thank you, Marty. Did you want to speak to this potential change or not?
Well, I think if he's allowed 72, then I would allow for 72. I don't know. I don't think that's the same for the hotel, though. Is it this?
60.
Yeah, the hotel is Old Town. They're limited to, that's 48 feet. But one of the things that went into the decision to allow for increased height has to do with the physical massing of the hotel, what that currently is, and how it's viewed from the elevation of that. So it's something that went into the special exception decision for increased building height for Gettysburg Station.
But as a transplant, I wasn't here when the hotel was being, when the additional height was permitted. But is it not true that they asked for a variance because of hardship to exceed the 48 feet maximum in the Old Town District?
I would actually have to go back to the record for that. I imagine that they should.
I'm seeing nodding in the audience. And I just think, if that process played out, that process plays out for the changes that might exist. But again, I'll stick to my concern about having revitalization in Gettysburg equal 72 feet.
Yeah, I can just, for me, to Sarah's point originally, we are specifically saying that this portion east of Carlisle is allowed to have 72 feet with some, they need to meet some requirements. But to Sarah's point, the building that's being developed there right now, independent of what we do today, will be allowed to build the 72. They already have their variance. They're good to go. John, to your point, I get maybe where staff is as well. Well, you never know until the building's built, right? So if that falls through, then, and we don't pass this, including 72 feet, then future developers would not be allowed, right? Because that variance would die with if they sold the property, let's say, or would they keep the variance if they sold the property?
I believe there would be a very good legal question of what unique circumstances have changed that the ability for the development of that property up to 72 feet can no longer occur.
Okay.
I would not assume that it would go away if a different owner had that property.
Okay, that's fair. That wasn't really, for me, it seems it's decided for that parcel, whether it continues, whether they sell it or not. So I find it particularly, personally, I don't really care as much about the height, but I find it odd that we're including an exception for something that already has an exception. And so I don't mind taking it out. It seems like last year, when this Ready Site project was ready, we had a lot of community input about the height. It was a little bit late, I would say, because it had been decided in 2018. But if something happens, this project falls through, we need to then increase the height as an incentive for developers. I would encourage the Borough Council to address it at that time. It seems like height is a pretty big issue in this town, and people have a lot of feelings both ways about it. And so I just personally feel like we're adding argument and issue to this rezoning process that seems to be a moot point for a building that already is allowed to be built. And so I would argue that we divorce it from this rezoning process, and then in the future, if there is a need, the town feels a need to provide incentives for more height, the Borough Council can deal with it independent of this process. I mean, we're doing a full rezoning, it's great, but of course the Borough Council reserves the right to change these ordinances again. And so if we don't do it now, I think they can just do it later if they want to. So I'm all that to say I'm in agreement that I don't know that we need this in the current rezoning.
Okay, Jenny.
Yeah, I think that I agree with Marty that it doesn't really make any sense to exclude the 72-foot height because it's something that's in there, as we've been indicated. It's something that's going to stay unless there's a compelling reason. I think that we're borrowing trouble if we're thinking too far in the future about possible expansions that haven't happened yet with the revitalization zone, and those can be handled at a separate time because we can't foresee all particular scenarios that could come up. And as Marty pointed to, the reaction to a different building height, I would not like to make such a restrictive change to the 4 parcels that are affected, which really isn't going to make a change just to prevent other problems that may or may not occur down the road. So,
Okay, thank you all, Planning Commission. John, it seems to me, and please object, that it sounds like there's a Sarah Kipp, Nick Redmond approach that John and I, your language was you can live with it, and I can too. And then a Jenny and Marty, similarly good and just approach that's a little different. So I know this isn't the staff recommendation, and I appreciate that that's a difficult thing for a planning commission to do, but I think you have our recommendation without objection to remove the incentives for additional height. But please, anyone object if I got that wrong? Okay.
Charles, could I say
Yes,
one thing?
yeah,
So, and this is probably a moot point if this is going to be removed, then what I'm about to say is it doesn't really matter. But to Sarah's point earlier, how we define this additional height is in 3 different places in the ordinance. So should it come back, should this go to the council and they say, we want to put it back in, then I do want to point out that there are some issues with how it's being worded, and I can always provide this to John later, but it's 3 different places in the ordinance. It's page 53, 73, and 102. And on page 53, where they start out with a 48 feet at the top, and then they have a superscript of 2, if you go to that, I think it inappropriately uses the word article, and it should use part. We've been changing that to part in a lot of other places, but in this case, it should be part. And then if you go to page 73, that's our table. And on our table, it calls for extended height as approved by right. But if you go into the supplemental regulations, it's by special exception. So I believe on the table, it needs to be changed to special exception because it has a lot of language in there of how this would be an application to the zoning hearing board to be able to go to the additional height. Okay. And then the last thing I wanted to point out is that there's another just a typo thing on page 102, John. It lists there, as you mentioned, there's 5 incentives. It just says 1 through 4. Yeah. So we need to make that 1 through 5. But the other thing that I wanted to point out is the legislation for the additional height. It starts with figure 212 on page 53. That figure, if it only points to part 3, it does not point to the use table, and the use table is the only place where it says everything east of Carlisle Street. So if you wanted to keep everything consistent, east of Carlisle Street should also be written into part 3. So again, those are moot points if we're going to delete this thing altogether, but I just want to make sure that was captured should this get put back in for some
That's
reason.
great to keep that language, that don't completely delete it from the universe, because council still has to do this. And I should also note, we're not voting on this to make a recommendation tonight. We're voting, as we have done the last few, or reaching consensus. And perhaps, and John, I know we are on a timetable, but it was always my concern that the revitalization district's benefits or incentives only applied to 4 parcels, and yet the revitalization district is like 12 parcels. So what actually was revitalized? What are the incentives to revitalize the rest of it? And maybe this now offers us a challenge to create what those other incentives would be. If it's not giving some height, maybe there are other items. And so that should be on our agenda or on the Borough Council's agenda going forward is my suggestion. Okay, now, A and B is finished, 1A and 1B, and it is 8:25 in the evening. I believe some of these might go a little more quickly, and I think we want to respect all the time that John put into this and all the time the community has come to listen to some of these or to respond to them. So perhaps some of these can move a little more rapidly. We'll turn to build 2 lines and front setbacks.
So this was a topic that's come up a few times. We have front yards, front setbacks, and build 2 lines. I just need some clarification on basically how the planning commission would like for this concept of a front yard, how it's that empty space in front of a structure, how that's actually being captured, and if what we're doing with build 2 lines is creating the attempt at least is to create a uniform like wall, so to speak, for the front facades of structures, so you don't have situations where buildings are mishmashed on the parcels and it doesn't create the same type of, I use language, the harmony and flow of the block. Gettysburg has, especially in the historic district, you have a very distinct built environment for the parcels. Overall, I just wasn't sure. I just wanted to bring it up since it had been discussed with it brought up to the commission in public comment. If it's acceptable, I think it would be beneficial to keep the concept of build 2 lines. When we're looking at parcel requirements, though, maintaining a front setback as opposed to having the build 2 line be the end-all be-all, if that makes any sense. If there's any comments or opinions or questions about that, we can move forward.
Any comments on this one? I think we received some comments from Sue Sipperly about this in our emails, and this did come up briefly already.
I would just note that the build 2 lines are fairly close to the street, as we are historic. It's what makes Gettysburg Gettysburg. So you will notice things like when there's a 48-foot building, they'll have to move the power lines which is kind of a unique thing, I think. I wish we could bury them, but Foursquare had to have theirs moved. If you just go out right out front here, come down to the steeple, and they cross over to avoid the steeple. So there's all sorts of interesting ways the power lines navigate this setback, but I don't know if it's a good thing or a bad thing. I just know the power lines have to deal with that. So just a thought there.
Chad, do you have anything on this?
I don't really have anything to add to the question at hand. There is something that I do want to discuss with John maybe after the meeting, and I'll just bring it to your attention so that you are aware that we're going to have this discussion. But I'm looking at this is the track changes version, page 151 of 198, section 403E. I had run into this in the past when I was the temporary zoning officer. There's a definition there that's confusing. In no case shall the build-to line be less than that of any adjacent building. And there's been some argument on what does less than mean.
Yeah.
So it could be clarified. I think we need to know exactly what the goal is with that sentence. If the intent is that it's all supposed to be moved to the forward and less than means further away, then let's say that. But I think that's really the only comment that I had, aside from do you want build two lines or not?
If it's acceptable for the planning commission, then the borough engineer and myself, we can redefine this and bring it back to you all in December.
Yes, I think unless others have comment, that's a good idea. And we can see that again. Okay, John, within reason, the land use table. I think we're going to be very targeted here, right?
Yes, let me.
And if you could tell us all the page number, if anybody's following along.
Yeah, so I'm going to be pulling up the red line draft, the track changes. Maybe if I can get to the table. That's parking, sorry. There it is. This is page, I believe it starts on 69, 70. Commercial. Yeah, 71. So starting on page 71, we've made numerous changes to housing. In particular, manufactured homes have been changed to special exception. This was something staff had recommended that they be defined a little bit more loosely, as there's the International Building Code, IRC codes allow for manufactured homes to not actually be considered manufactured homes if they're placed on a permanent foundation as opposed to being on a chassis. We've since struck that, going to a scenario where the permission for a manufactured home would require special exception. This is beneficial. Often the installation of a manufactured home is done in a manner that is more shotgun style, which may not work for the actual built environment, especially if it's more about economics for frontage when they're sited like that. So those are some of the things, and you can have some manufactured homes that are a fantastic product, and they had one for a while about 10 years ago called the iHouse. Like, they have some really futuristic things that you can make in modular construction. So allowing for the option for it to occur is still beneficial. Additionally, looking at the industrial district, a lot of the housing is now going to be permitted in that district as a special exception. This was requested specifically for our larger industrial buildings, the potential for brownfield redevelopment to have a residential use, providing additional opportunities for residential housing. For lodging uses, we've since removed in as a by right use in industrial and have changed that to special exception for inn and hotel. Temporary shelter facility has been removed from the R2 district. Going down further, the hospital use, we also have included that as a special exception in the general commercial district. Quite a few changes for the forestry and open spaces. There were some issues we discovered with the recreational facilities. So we've made sure that those are permitted in the general commercial areas and the revitalization districts, and also permitting for them in the industrial district. Adult establishments, we've refined that to only be permitted with special exception in the industrial zone. The brew pub use has been expanded. We put that into the revitalization district now. That when we had a discussion about that previously, it was omitted for some reason. The farmers market use has been increased to some of our larger land uses. So for like industrial zone, the institutional zone, and healthcare zone, there's places that have large parking lots. You can have a farmer's market there. It makes sense. Funeral home has been included in the R2 district as a special exception. This is in relationship to the Carlisle Street funeral parlor that's it's currently in existence, and with the proposed changes, this would allow it to still be a permitted use in its proposed rezoning classification. Let's see, a medical clinic, allowing that in the Old Town and Revitalization District. Microbrewery, distillery, allowing that in revitalization with special exception. Getting rid of neighborhood retail and neighborhood service. Those that were not clearly defined, and frankly, the general commercial uses as defined already captured a number of those types of smaller. It was a scaling thing that was being utilized for those definitions or for those concepts. Tour operator has been expanded into numerous districts by special exception, and the the civic institutional district as by right, and I believe Helistop removed from the civic institution. A number of changes. These appear to be a number of changes, but actually it's just moving things around for no impact to home-based businesses and parking. That concludes the table changes that we've heard.
So John captured the discussion in our last meeting as well as some community input, and it's now our time to make any changes to this chart before we move for recommending it. Any questions or changes? I have one that I don't want to go first, so others.
So one of the changes this is just my personal thought, but under residential uses, mostly, right, we have R1 and R2, right? So R2 has pretty much every residential use you can have, some by special exception, most by right, versus R1 has fewer, I think, low density versus medium density. The one that stands out to me is single-family semi-attached townhouse. I live in R1 on Ridge Avenue. There are townhomes that would meet this definition in that neighborhood already. And again, for myself, my whole thought going into this was to increase housing stock. So to me, I would personally wouldn't see why we wouldn't have special exception at the very least for that. I think it allows you to have more units on one property than you might have before. You can subdivide and take less room for each unit. So again, I know there was a lot of conversation around student housing. So I think from community input, I can understand why that's not included in R1, but I just don't see why we wouldn't allow for the possibility of townhomes in R1.
So Nick is making a suggestion for R1 special exception, single family semi-attached townhouse.
I support that.
I would also support that.
Any thoughts, John?
I would support it.
Okay, so let's add special exception for single-family semi-attached townhouse to R1. Special exception.
I think that's fair. Again, what we've talked about special exception in the past is it gives the neighborhood a chance to weigh in and just be aware of any, it might be a major change to that neighborhood, a property being turned into, 2 townhomes, let's say. So I think special exception is fair. It gives the people in the neighborhood just awareness that it's happening and a time to respond with any issues, rather than, suddenly seeing a construction project on their street. So, but it doesn't stop the person from having the ability to do it.
Just so, like, how many townhouses are in R1 now, do you think? And they would only be in one section of R1, right?
I do not have an analysis I can provide.
Okay, so there's that recommendation. My question was about the R2, and I guess this is why we need that student dwelling definition. So should you get recommendation from us to keep the student dwelling definition for this? I'm sorry, yes, dwelling student housing that you proposed in the memo?
So, as it is, I mean, student housing primarily relates to fraternities and sororities, with the exception of those student housing institutional.
Yeah.
If you want to make it tighter, staff has provided some language that would further restrict student housing to any type of building that's being occupied by a group of college students.
And was student housing in the R2, is it in the R2 in the existing draft?
I believe in the existing ordinance?
In the existing ordinance.
Yes, I believe it is.
Because it just seems that on Carlisle, there's a stretch of Carlisle where, yes, there are large homes that house fraternities, but that in the R2, there are not. So I'm just questioning why we would want to encourage them there and not keep them to where they already are.
One reason the R2 district is your higher density housing. A fraternity, sorority, there is a college connection to it, but being in the code world, it's a multifamily apartment house that has, and generally, it either has a dormitory type of focus or it's just suites. It's no different than any other multifamily, with that exception that of the who's going to be residing there is exclusive membership.
Others have a topic or a question related to this student housing in R2.
It is a little, so, because there's student housing, which is defined as, right, a multifamily dwelling with rooms for rental to students, and then it specifically calls out fraternities and sororities. And then there's student housing institutional, which is dwelling in accordance with another part that's owned or managed by a public or private educational institution. What's interesting about Gettysburg is you have fraternities that fit both definitions. So the fraternities on Broadway, Lambda Chi and Sigma Nu, are privately owned by the alumni associations, yet fraternities on Carlisle are owned by the college. So would they fit the definition of student dwelling fraternity sorority or student dwelling institutional?
Staff would probably go with the institutional based on the ownership.
Thank you.
I was just saying, we do have an opportunity here to listen to maybe some neighbors in R2 who have expressed concerns about current and future, and I wondered if this isn't a chance to sort of put some more boundaries around the growth of these.
So, I looked up the R2, and student housing is special exception, and there's 3 requirements under that. So I don't know if they met those requirements or in terms of current.
And we're having a special exception here, so that wouldn't be a change, but are those requirements carried through?
Let's pull that up. So the current definition of student housing, I believe it's defined. Okay, yeah, it's a multifamily dwelling with rooms for rental to students. The owner or person responsible 21 years of age or over shall live on the premises. That's the current definition. Institutional dwelling in accordance with subsection 271524, subsection 211.1, is owned and managed by a public or private educational institution or school for academic instruction with rooms for use by students, such as a dormitory, sorority, or fraternity, whether located on campus or off campus. So what we're proposing then, if I can pull that up. Keeping the multifamily dwelling with rooms for rental to students, the owner or person responsible 21 years age or over shall live on the premises. But then we also have specifically fraternity sorority defined within that section. Those were previously separate definitions. And then institutional, same language that's currently in existence. Whoa. Let's see. Yeah, so it's the exact same definition as is now.
So we're not making a change. I was just suggesting it would be an opportunity to, if there is will on commission, but you'll have to share if you think so.
So we're discussing the inclusion of his definition of group? Is that what you're?
Well, I was more suggesting that we take it out of the R2 altogether, but.
Charles, I think one thing to consider too, I think when we were looking at this, a big change that we made was along Carlisle Street on the map.
Right.
Removing a lot of that from institutional and adding it to R2, with a recognition that a lot of that is owned by the institution, but again, with this future mindset of if they were to be sold and changed, what do we want them to be? The answer is houses. To your point, though, with some of the feedback from community members, I do think there is a difference between student housing privately owned and student housing managed by the institution. I think a lot of the concern from the community was ones that had no connection to the institutions. And so maybe a compromise is continuing to allow student housing institutional for special exceptions. So if the college has, there's a building on Carlisle that is currently used for the economics department, but used to be a fraternity house. If they needed to change that back into student housing, they could have a hearing and be allowed. But again, some of those community concerns might be mitigated by the fact that it's owned by the institution and managed by the institution, versus if a privately owned fraternity would like to purchase a home on Carlisle, then not allowing just the general definition of student housing there might be a good compromise for that.
I like that, Nick. I would support that. Others? Okay, so if there's no others for that, then that probably means we're not going to forward that.
Will you just say it one more time, what actually the proposal is? Sorry.
Well, so
Sorry.
just as I don't personally mind student housing either way. I think, though, thinking about community concerns, though, I do appreciate people coming forward and talking about these issues. It seems like the issue people have is with non-college affiliated student housing, and so there seems to be two things allowed in R2 right now. One is non-college affiliated, which is just dwelling student housing, and then college affiliated, which is dwelling student housing, institutional. And so since the community's concerns were more with non-college managed student housing, do we eliminate that entirely in R2 and only continue to allow institutional student housing in R2? And so any, private fraternity or pseudo-fraternity, I guess pseudo-fraternity wouldn't apply here because you have to be defined as student housing. Any private fraternity would not be allowed to purchase a property on Carlisle and turn it into a fraternity house. But if the college needed to change one of its properties to be from office to student housing, they would still be allowed to do that.
Okay. That makes sense to me. So you're saying would there no longer be any special exception for student housing?
The first item,
R2.
yeah.
I agree with that.
Okay, so there are 3 on that. Would others like to yay or nay? We're talking about removing special exception under dwelling student housing in the R2, but retain it for student housing institutional. Okay, I'm getting yeses and no objections, so if you could take that advice, John, thank you. Any further items related to the land use chart?
Did we get Mr. English's concerns addressed there with the event?
It should be permitted by right now in the NC1. Let me just make sure.
Yeah, it is.
It is, okay, yes. Yes.
Thank you.
There it is, yep. Thank you, Marty. Okay, then let's move.
Can I just
Please.
say one thing
Yeah,
real quick?
John, yeah.
Yes, so, and I did my review, all of the notes that I had made over the course of the last, whatever, 6 months or so have been reflected in the new track changes version. There was one item, and forgive me, my notes were unclear on it, and I know we touched on it, and I just can't remember how we landed. So we may have already satisfied this, and I hate to revisit something that we've already visited, but just to make sure that we're crossing Ts and dotting Is here. Under lodging uses, the bed and breakfast, under R2, we had a lot of discussion on. We have it currently as by right. I had a question mark by special exception. It's on the first page of them.
That's a good point, yeah. John, do you recall how we landed on that, or didn't we address it?
My there was concern about it.
And I was looking at my notes, and I just don't know that we ever kind of had a consensus. There was a lot of concern, and it just kind of got left open-ended. At least my notes were open-ended.
Thank you for picking that up. I think, maybe some of the concern was that bed and breakfast is perhaps on a residential street, something that those residents should know about before it goes to be built and transformed, and so special exception gives that advertising and considerations. So I'm seeing nods. So to change it from right to special exception, bed and breakfast R2.
Yeah, I think initially we had taken it out completely.
Okay.
And then we put it back in by special exception. So I think there was consensus at the last meeting.
Okay, so John, if you could do that, thank you. Others, and thanks, Chad, for looking over the whole table.
I don't know, this might be opening a can of worms, but, I mean, there was that young lady's conversation about chickens.
Put it back in.
I missed the chicken conversation originally. I personally don't really have a strong preference, but I don't know if there's any desire. I missed the reason why we took it out.
So
There are
that,
strong feelings about that.
yeah, I think there are strong feelings. They have not been presented in any public meeting, and we already took it out at a previous meeting. So I think to put it back in, we would be inviting problems without advertising it in advance and having the people be here to speak to it. Solicitor.
You haven't decided anything, so you can do whatever you want on it, but I think you have to decide how much you want to weigh, public comment received on that versus moving forward.
Right.
I think keeping of bees and keeping of chickens was all part of that same discussion, so it's just a question of whether you want to revisit a topic.
Yeah, it had been on the agenda, and we removed it. And but of course, Commission, please, I just think that if we didn't advertise it, that we were having it on our agenda today, that it might give us some grief.
You
But
can
we
also
could
talk
revisit
about
in
it at a subsequent
December.
meeting.
I'm fine personally with, I don't really have an opinion. There's the one public comment I feel like we didn't address with any of our conversation at this point. But to your point, there was a lot of previous public comment that was against it, so.
I may have asked this before, but what do you do about existing chicken owners? Because I guess there are some. There are people in the borough who currently have chickens. So what does it mean that it's not addressed in the ordinance?
I mean, I'm unaware of any complaints associated with chickens. We do have other provisions in our code of ordinances that limits this was something staff discovered. Apparently, a lot of agricultural uses were dissuaded and banned. I believe it was either 1936 or 1937, which was odd because it's like the Great Depression, but I think that might have been the
Sure.
reason, is there was a lot more agriculture that may have been happening. As such, that would be something if that came up in previous comments, was that, well, if we're changing the zoning ordinance to permit it, then we also have to change this other provision in code to allow for it as well. So as it is, it would be something that's more of a police matter. And if there would be a land use situation, it would be something that it hasn't come up, and it would be something that we would probably have to investigate how we would handle it from a zoning perspective. I really see it more as either a building code issue, because there'd be other issues associated with having either chickens or farm animals, things like that would come into play, as opposed to just the practice of having the animal in the house.
I think that's a good answer for us not to do this. It's already prohibited in the municipal code. Should we want to explore it as a community, the Borough Council has the opportunity to add it in when it's on their table. And we have many more items on the agenda that people came to address, and not that one. Okay, all right. Other land use items for the table? Then let's move, thank you, John, for updating that. Let's move to the higher density residential.
Well, we've already hit that to mostly with the student housing. That was the real outstanding portion for what we needed to do for our housing. One thing, let's see, we did include a number of uses in the industrial zone. I haven't heard any, I guess, negative feedback for that. So if everything's okay, we can proceed with the, I guess the only change would be for lodging for bed and breakfast at this time.
Yes,
Yeah.
correct. Okay, without objection, let's, yeah, go ahead.
I had a question that is maybe not, I think this is probably the best section of the agenda to bring this up. I didn't know what you were going to talk about with this higher density residential, but I thank you for providing the written comments that we've received from the public. I'm really appreciative of some of those very clear, and it looks like people spent a lot of time on the ordinance, and it made me revisit the dimensional standards of some of them. And, you know, we've talked before about how this board previously reduced the lot width of, I think it was R2, which in the proposed ordinance, I think is 20 feet. And then the next R1, the lot width is 60 feet. So to me, it seems like lots 3 times larger in the R1 don't meet the same goals as trying to promote increased density possibilities. And in fact, I think it was Susan Noggle perhaps, or Susan Sipperly, that there are already plenty of lots in R1 that are smaller than 60 feet. And then I went and measured some I'm trying to remember, West Lincoln has 46 feet, South Ridge has lots at 50 feet. So it seemed to me that we should consider reducing the lot width minimum in R1 to something that at least allows what exists there to not be non-conforming. Thank you for that word, yes.
What staff can do is we can do an analysis of our lots of record and see what we're looking at in terms of full central tendency, seeing what our mean, mode, and frequency is for the R1 district. And if it makes sense to lower that number, then we can proceed and get that information in December.
Great.
Okay, thank you.
Thank you.
So if I'm tracking, that's only the second thing we've asked you to come back with, but there are 2 now. Transparency.
So this one, we get into transparency, but we really don't have a good definition. What I had suggested to the chair, if I can spell correctly, transparent fences, yeah. When it comes to regulating building windows, building window glazing, this is something the ordinance could do. I guess it's not something that I've heard any real comment about. I wanted to just see if it was something that it was, I guess, wanted or desired from the commission. But maybe move on.
Yeah, this is some public comment was relating to this, right? With the, thinking it referred to windows or something? I don't see what that was now, but, because this seems to be okay. Or I guess not.
Yeah.
John, to tell you the truth, I do not remember where that came from.
What I'll do is I'll go back. We might have to we will reinvestigate this.
So that's the third item. Okay, revisit that.
Yeah.
Additional text edits. You have already responded to quite a bit of small typos and numbering and word choice, and I think you've cleaned nearly all of that up. But was there anything you needed us to respond to?
If there was anything that the commission had that they felt would be necessary, I will be meeting with Chad to discuss some of the edits he's going to be, that he's identified. So we can have some further changes to the document and have that out prior to the December meeting.
So that in particular relates to 27-418, the streetscape design section. So that might be a place, Commission, where we eliminate in the streetscape design section everything but lighting. If I understand this correctly, this is a drop-in from the former streetscape overlay?
Yes.
That the thinking is, and Chad, you speak to this, that this will perhaps move into the saldo, hopefully in short order, but we can't guarantee. But that we need to preserve the lighting, most importantly now, but perhaps not the rest. There are some questions about lighting, though, in that who follows these lighting design guide? Anybody? When the borough does lighting, do they put decorative streetlights, or are residents having to do it as well?
Only when triggered by a land development, which is exactly why this would make more sense in the saldo ultimately.
But why do you want to keep lighting then?
It is an important thing for the borough for consistency of the bike trail components for different streetscapes. If we get rid of it out of the zoning ordinance as we're writing it today, there would be a silent time where someone could do a development and not have that consistency of the decorative streetlights. So there is sections in our portions of the borough where we do want the decorative streetlights, and the council has made that pretty clear. So I think it should still be captured, and it's probably the most important part of the streetscape overlay district. As we've done reviews of different land developments over the years, that was the one item that had come to developers' attention the most, that they had to do these decorative streetlights with their developments. So this ordinance does capture that component. There are plenty of other, I could go on for another 5 minutes about different sections of the zoning ordinance that make reference to the street and sidewalk ordinance, to the saldo. There's other better places for most of that. And now that we've gotten rid of those overlays to try to clean up our document, they just don't really make sense here anymore.
So taking Chad's advice, and John, you agree, my recommendation is we remove that language unless there's objection from the commission. We don't have to discuss it now.
Just to confirm, this would be to remove everything except for the lighting, decorative streetlights, and building lights section.
Yes, from 27-418. Any objection? And we'll revisit that with the subdivision and land development ordinance. Are there any other additional text edits at this time? Okay, so then next, John, these are the three districts that we have not discussed. I don't believe, but I could be wrong, that they are going to need a lot of discussion, and so you may not have to walk us through every detail. And I realize, I think there are people in the room that are here to talk about their parcel related to the map discussion. So I'd like to maybe have you guide us through what you need and ask us what recommendation you need from us. And then we do invite the 2 or 3 people in the room before we make any moves on the map to tell us one more time what they're requesting, and then we close with the map discussion.
Okay, yeah, now I'll try and keep this as simple as I can, which that's a problem already. Okay. NC1, NC2, NC3. It's kind of like a sliding scale for your mixed use zones. When I say mixed use zones, we're saying those that have residential and commercial uses. NC1, those are the areas right around the Old Town District. They're in the downtown area. There's clearly a different type of built environment. Many of these properties, especially those that were there to the west of Baltimore, they're currently in the Elm Street Overlay District. This NC1 district allows for quite a few commercial, not necessarily full-blown retail, but a mix of uses. The real fear that the steering committee, that group expressed, was that the Old Town, you're allowed to do a lot of commercial. You're allowed to do so much commercial, in fact, that it becomes more lucrative for property owners to have commercial enterprises as opposed to residential housing. And so this is an attempt to encourage more residential while still preserving these building facades and building designs that are historic in nature and contribute to the vibrancy of the borough. NC2 is pretty much Baltimore Street. These parcels are unique. They're all fronting this primary corridor. Baltimore Street itself is going to be targeted by the borough for future pedestrian improvements, sidewalk improvements. So this area is going to be more of the almost 50-50 mix. As we have now, there's a lot of commercial opportunities or commercial businesses that are taking advantage of this corridor. It is more of a pedestrian corridor. It's something that's being built as a pedestrian corridor. So fewer of those automotive intensive uses. And then finally, there's NC3. And these are the areas which are these orange areas that are along our highway corridors along 30. So you have Buford, you have York. Really, these are areas, these parcels are larger, they can accommodate automobile parking. We have the mix of more of our commercial restaurant uses, gas stations, things like that, with some housing. This is more of we're getting more to heavier commercial, but still maintaining some residential opportunities in these locations. And that's where we are now with this. There has been, I guess, a lot of concern regarding the changes from the old town to the NC1. We haven't really received any comments regarding NC3 or NC2.
Okay. Do any planning commission members have any questions or corrections or recommendations for these 3 NC districts before we invite those here to speak about their parcel on the map, which some, I think, have to do with this NC district? Okay. Then if anyone would like to use this as an opportunity, I'm inserting public comment here because we're going to close this meeting by discussing the map again and then the process timeline. But this would be your opportunity to speak about the map and your parcel or request for change. Go ahead. Would you mind speaking from the podium? Oh, I thought he was.
Suzanne Castile. I live on near the Adams County Arts Council on South Washington Street. And I have a bed and breakfast, which I love. They keep it beautifully and no problems next to me. So my concern initially was when this was changed to the NC1, whether businesses would still be allowed to continue in the NC1.
And I think we did resolve that. Remember, at the 2 meetings ago, I think we
resolved the fact that if I would want to rent the first floor of my residence to someone, say, who wanted a legal office, someone who wanted a professional office of any kind, I would be allowed to do that.
Yeah, it looks like an NC1 office use is defined by right. And so office use are typically those businesses that are kind of by appointment, not so much retail, but like to your point, law office would fit within office uses. So that is by right within NC1.
Well, what about a retail business?
John?
Just look, I mean, I think it's more.
Well, there's let's see, there's restaurants with special exception, like brew pub or eating place. There's also, let's see, you can have a vape store, you can have an event venue, funeral home, general commercial service uses. So those really can capture most of the personal services that are going
So
to be.
if we wanted to have an art gallery, which had been in there at one time in our property, we could?
I believe so. Let me
Well, we have the Adams County Arts Council right there, and they're having exhibitions, events all the time, and everything.
So an art gallery is included. Okay. Oh, that's a commercial service use.
So it would not be included?
It is.
Oh, it is.
By right.
By right, yes, by right.
It would be permitted for
Yes,
us
yes.
to have,
Yes.
like right now, my husband rents a space for his art gallery, but if he wanted to have it on the first floor of our home, it would be permitted in the NC1.
That's right. So we're good.
That was changed from special exception to by right.
By right, yep.
So you're saying any kind of low-impact business that doesn't have a lot of constant traffic, like a McDonald's restaurant or something, is what would be permitted? Whether we're doing it ourselves, or whether we would be renting that space to somebody else for that purpose.
Yes.
Yes.
But we'd be allowed to rent to somebody else, say they wanted to have an office, an art gallery, that kind of thing.
Yeah,
Yes.
There's
Or a
lot
little
of stuff.
retail shop. Maybe they just wanted a little retail shop or something.
And that would be permitted.
It
That
seems to
would
me
be
that this
permitted.
district is actually perfect for the kinds of things you've been outlining at this meeting and a few other meetings, that it's actually exactly what I think you're trying to do or may do.
Yeah, there's a lot permitted. Antique shop, art gallery, coffee shop, craft store.
You can have all those.
Yeah, locksmith.
Well, I was concerned because our zoning on our street got changed with this new proposal. You know, so I was concerned about business purposes because we don't want to lose value of our property because it can no longer be used for business purposes. I mean, second floor is residential, but the first floor is all business. Nothing's, so you don't want to get into a situation where your home is being devalued because of a change in, all of a sudden you're not allowed to use it for anything, so to speak, but you're saying all these things are permitted. Because we had been in the Old Town district before where we lived. So
I think we'll move on. I know there are some others here, but I'm happy that we were able to answer your question. We're still all good. Nothing's changed. Thank you, Ms. Castillo. I know there might be one or two others who want to speak to a parcel, so are you coming?
Can we speak about not a parcel, about a previous discussion?
No, not right now. You can wait till the end of the meeting for that. This is specific to what's coming up on the agenda, but we do have one last public comment. So, sir, and then Ms. Michaels, and I think that's who I see left in the room who wants to speak about parcels.
I'm Don Schmetz, and I'm counsel at Foursquare Church. At the last meeting, we requested consideration of changing the zoning for the church from residential to commercial. That was followed up with a letter to the commission dated October 23, where we set forth our various concerns and our arguments. Did you want me to?
Well, the commission has received that letter, so you can know that we have received it and that we will be talking about it in a minute. If there was anything additional that you wanted to say, you could, but we have received your letter.
Okay, well, it depends on what the commission decides. But I
Okay.
think that's it for now.
Thank you. Ms. Michaels.
Sharon Michaels, 120 York Street. Thank you for allowing me to ask some questions. Let me begin by, I'm also in the downzoning from Old Town to Neighborhood Commercial 1. And given that the uses permitted by right have changed, that makes me question what the difference and why the change in designation from Old Town in the particular block that we're on, because I know that block has occurred, and what that means. And I think I'm curious about parking and what the parking changes would mean in terms of running a business on our first floor. John, can you address that for me?
So the Old Town District currently does have a parking allowance whereby there is no maximum, well, let me make this, let me rephrase this. There's no required parking for land uses in the OT zone. In the NC1 district, you would have to comply with the parking regulations for any new uses. What we've proposed with this ordinance are parking maximums. Generally, they're just, for most uses, you're looking at minimal parking requirements. I can pull this up real quick.
I think we have a maximum of 2 spaces, which isn't, and doesn't, as I understand it, include street parking, metered parking? It can, okay. So we can exceed the 2 if they're using metered street parking.
Well, you can, depending on the number of parking spaces that are permitted, the maximum number required, you wouldn't be able to go over, so on the parcel, you aren't able to go over the maximum. You're off the parcel, you're able to utilize street parking as necessary. For those uses where you have to have a minimum amount of parking, you can also utilize certain spaces within a 1,000-foot radius of the parcel.
Okay. So again, I have the question as to why we're being downzoned. And I'm suspecting that some of that has to do with population density.
Well, maybe Nick or Sarah, do you recall that part of the ad hoc committee to help John here?
Yeah, I think generally looking at, especially NC1, you have these areas that are, you have the center of town, right? You have the square. And then kind of branching off of that, you have what is Old Town, but Old Town used to extend further, particularly along Carlisle, or Chambersburg and York. And so it really was that idea. I mean, again, a big thought of the committee was housing, right? And so we wanted to provide for more housing in this town. And one way to do that is to not disallow anything that currently exists. Again, if you have a business and you're being rezoned, your business is not being affected. It's if that building were to be sold, the use were to be changed, we would prefer that change be into housing. And I do understand, to your point, and to some of these points, yes, that could potentially affect the resale value of your house, but I think we need to think beyond that to the community, right? For everyone, the best resale value would be do whatever you'd like with your house, because then you can sell it to whomever you'd like. So we need to make decisions based off of what do we think is best for the community. Our thoughts were, well, let's get it a little bit more residential in NC1. That being said, if you look at the uses table, there are very few uses that are allowed in Old Town that are not allowed in NC1. Me personally, I would prefer that be more restrictive, but I think with some consensus from other folks, you're really not losing too many uses transitioning from Old Town to NC1. There's a few, like grocery store, for instance, convenience store, farmer's market, parking structure that you're losing. But other stuff, all of those office uses we discussed earlier are still allowed. Massage establishment, medical clinic, it's not a huge downgrade. And so I understand it can feel like a big change, but if you look at the uses table and you compare what's allowed by right or special exception in Old Town and what's allowed by right or special exception in NC1, not a lot of difference.
So if I sell it, the people that would buy could still have the same uses. They wouldn't be restricted to residential.
Adam Boyer, why don't you respond to that? The use continues in sale, okay?
Yeah, so if you have an existing use and the ordinance changes and that use is no longer permitted in that district, you would be a non-conforming use and it can continue, subject to reasonable expansion.
Okay.
But if it's not an existing use and it would propose to be converted to something after the ordinance is amended and prohibits that use, then you would have missed the boat, essentially.
So moving on to the discussion about increased density, I take it that probably nobody on the commission actually lives in that area of town. Maybe I'm wrong. But
Which area?
in the blocks that are being converted from Old Town to NC1.
No, at least
I live in Old Town, I guess.
And specifically, I'm looking at the block that I live in on York Street. The density right now is pretty high in that area. The houses are more like the ones in Old Town where they're built, to the sidewalk. There's no side yards. You have alleys in between the buildings. And people have all kinds of auxiliary units that haven't been in use because they haven't been allowed, but will now certainly be in use. So it's a pretty densely packed area already. Between the density of people and the density of the traffic in that area, I am concerned that what is being created is a situation where nobody's going to want to live in that neighborhood, and it really won't be usable for neighborhood purposes. So that's something to consider in terms of packing density all into a few areas in town versus spreading it around more. Agreed that maybe we need more housing. We certainly need more affordable housing. But it seems like it's being really focused into the pink areas, which not everybody in the NC1 districts are subject to the same kinds of traffic, both walking and car traffic, that we have on York in the block that's being proposed for change. But I can tell you, I have hundreds of people probably on a weekend, anytime on a weekend, walking by my house. I have neighbors so close that I have to play music because I can hear them. And it's that way up and down the street. So I just, would ask you to consider how much density you really want in one particular area.
Thank you.
Sorry, I think when the part that I recall about this discussion about this new neighborhood commercial districts is that we were trying to recognize that those areas already do have many existing commercial businesses, but they have a relatively low impact on residential areas. And, the idea was to try to allow things that have, keep daytime hours and hopefully reduce the impacts to residential living. But so I'm interested in your concern, so thanks for bringing that up.
Yeah, absolutely, and thank you. Let me see quick if I have any other. And this is another question for you, John. Because we don't have side yards, and I think, see that everything in NC1 needed to have a side yard. Are we non-conforming then because of that?
So if you're not meeting the current setback standard, that would be a legal pre-existing non-conforming structure.
Would that impact our ability to sell it or do anything with it?
It would impact your ability to further expand the structure's nonconformity. So if it's going to the parcel boundary, you potentially would not be able to do like a rear addition in that area that's not meeting the setbacks.
It looks like neither Old Town nor NC1, they have side setback of zero minimum.
Well, Old Town does, but NC1 did not, unless it's been changed.
Might have been changed. It
Might have
says
been
zero.
changed.
Yeah,
On the
it's been
current
changed.
draft, it's
Okay.
zero.
On the front, but also on the side?
Both have side
Okay,
zero.
great, thank you for that.
Thanks for
Okay,
checking that.
thank
Thank you. So let's move to, is this about an existing parcel?
It's about a map.
Okay.
One of them is showing 5 stories, that's showing 3 stories.
I don't know quite what falls under your map change things, but previously I had mentioned the commercial thing where the railroad, well, it was proposed to be changed to industrial.
Yes.
And it's currently commercial. And the rationale by the consultant was that there was a railroad track there. And I've looked in person and on aerial photos. There's no railroad spurs on the south side of the tracks. And there used to be down on that big open area where the fire hall is. But also the existing uses, there's only one building that's still like a light industrial use. So I was wondering what happened to that situation. Did you make a recommendation on it?
Thank you. I don't recall.
Yeah, so that's going to be changed to the red for this portion of this purple area that's within the dashed black
Okay.
line. That, I think, 2 meetings ago. We haven't updated the map fully from those changes. There's a few other parcels that are that are like owned by the Battlefield Trust that we're going to have changed, and then a few that were requested for residential R1A to be reverted back to R1.
Okay.
Both sides of the railroad track, that is in that purple area with the historic.
I do not believe I believe it's just the south side.
Okay, is this a time to address that particular area too, or?
If it's about the map, yes, we're going to move to the map here. So if you wanted to come back over here, please. And then, John, my guess is that we're going to do the map, but that'll be like the 4th item in December for a final map.
Yep.
Comments.
I had spoken previously regarding my concerns about having industrial use in that area because of the density of people that live in that area. And, the borough's only 1.7 miles square. We have somewhere between 7,500 and 11,000 people living here. You start putting light industry in there, even if it's light industry, and then you have the probability or the possibility, at least, especially if you involve the railroad for transportation, of toxic spills like they had in Ohio. I did notice that there's something now in the requirements that people have a plan for handling toxic spills if they're in that area. But I got to say, I think it makes sense. I think we really should consider why would we want to jeopardize the health and safety, which is supposed to be one of the purposes of the rezoning, by putting things in there that we know potentially down the road can cause problems. The same train that ran through Ohio that had the accident and the big spill here about a year ago, that same company runs on that track 2 or 3 times a day. There are 2 companies that run on that track, and they carry between 6 and 16% of toxic material on any given run through there. Plus, if you start allowing light industry, and I think we already have this situation with Spectra coat, that some of the materials that they use in the industry can be toxic. And maybe they can be contained, maybe you can build a warehouse around them, but you still have the potential for that happening. I know we need jobs, but there may be better places in the county where if you have a spill that's going to impact people for a square mile, it isn't in the borough, which is 1.7 miles squared to start with. I strongly urge people to wrestle with your conscience about putting that kind of thing in that area. There are if you look at the Joint Comprehensive Plan, which I think we were directed to, and I did read all 471 pages of, the recommendation was not for industrial in that area. The recommendation was basically keep it as general commercial, but also to use it as a riparian area for wildlife and to have green space around those railroad tracks. And every place else that we have looked at, you were trying to stay in keeping with that joint plan. So this is a huge departure from it. And I would just ask the
Yeah.
council to, or the commission to take a look at that.
Thank you for addressing that. Does anyone on the commission well, actually, let's deal with that in turn here. John, do you want to guide us through anything that was on your list? You particularly highlighted the NC2 Historic Corridor Neighborhood
Yeah.
Commercial, but
That was brought up prior. Specifically, the request was for NC2 to be expanded into this area, Carlisle Street, that's currently zoned the RO. Just for discussion purposes, as it was a request.
so if I could lay these three out, there's that one, the concept of RO in, I'm sorry, NC2 in that district. There is some lingering concern about West Middle Street, where Foursquare Church is, but also some other properties towards the end of town. And then here's a third related to the industrial. So it's 9:30. I imagine that the commission will certainly want to discuss and think about that industrial more, since I don't believe we have put in the time. But would anyone wish to discuss right now and make a change to the map related to West Middle Street, since this is the second time that this has been brought to our attention? And John, do you want to explain that, please?
So, in particular, the church property, the request is for it to be zoned general commercial. The parcel does abut a proposed general commercial zone, so it would not be spot zoning. One thing to keep in mind, the land use, places of worship is permitted by right in the R2 district, so the current use would be permitted. I believe the applicant has made clear that this is concerning the value of the property and their future use / the ability to sell the property. So they have that concern, totally natural concern from the property owner. The only limitation that is, I guess, concerning for this area is that floodplain. That does limit the availability of development in this area, but otherwise, it's a very large parcel, it's a very large building. It's something that that structure's continued use would be even in the R2, you can still do multifamily dwelling. There's other opportunities to utilize the property as opposed to going through the general commercial. But this is naturally the planning commission's bailiwick.
Do you want to talk about further down or just limit it to this?
Well, that's the main one. Further down, the closer you get to Hay Street, the request for some of these larger parcels, they're being utilized as office buildings now. I believe there's a bank, the podiatrist, Sites Realty. Those are, the office building uses are permitted with special exception. That would not change. The properties are currently zoned R2, so this isn't a change in zoning.
Okay.
It has been requested by the property owner, so it's just something to keep in mind.
Okay, do commission members have any discussion on the R2 here and maybe making changes from what we heard?
General commercial is pretty restrictive on housing, correct?
Let's see. So general commercial. Yeah, you can do multifamily apartments and sober living facility.
Well, if we're trying to create and preserve housing stock, then we'd be limited to that one use in the future. Otherwise, I think general commercial makes sense since it is, they have a fairly large parking lot, and if staff thinks it's a potential or doesn't have any.
Well, yeah, it's not that staff's recommending it be continue to be R2. The availability of the general commercial district in that parcel that butts it does allow for the commission to consider general commercial without spot zoning concerns.
And what type of businesses would be permitted in general commercial, and are they advantageous to that street?
So in terms of the, let's see, we have automobile garage, car wash, fuel service, bedding uses, brew pubs, a lot of
So that's enough for me. I mean, unfortunately, for the applicants on that street, I perceive that street to be residential and office, even with Kenny's.
and you can do office uses.
Yeah, right, exactly. That's what I'm saying. I perceive it to be that, so I'd like to keep it in the R2, personally related to how that street seems to function currently. Those uses seem like a pale beyond what that part of the street is like. But that's my concern about it.
I would echo that. I live on Ridge Avenue, so I walk down Middle Street every day, pretty much, to and from work. And while I appreciate your perspective, as I said earlier, for the individual homeowner, the best thing to do would be to allow any particular use that they would like. That's going to increase their individual resale value, sure, no question. But we need to think about the community in this aspect. And so understanding that that is going to be restrictive for some people's uses for resale value. And so I think this is something that's been R2 for the last however many years. We're not taking it from general commercial or from Old Town or anything and trying to turn it into R2. It's been R2. The current use of what the building is allowed in R2. And it's my opinion that if you were to sell, if the property needed to be sold, I would love to see a chunk of housing get dropped into there. A bunch of homes could fit right in that, space, right? Or continued use as a church. I'm not against that. But to Charles's point,
Or
general
office
commercial
space,
allows, or office space. General commercial just allows so many things, a shooting range, like all those things that, to me, does not fit the character of that neighborhood. And to your point about Kenny's and others, I would be in favor of moving them into R2 as well, but I think I would be outvoted. But so it's not particularly about that parcel. I am just solely in favor of anything we can do to increase housing in this town, and I see that as a way to do that.
Others? Sarah agrees. John, Marty? Okay, once again, we will make a recommending vote at a future meeting, not today, and you can speak at the end as well to this, and then we come back to another meeting. I'm not hearing any recommendations for anything else related to West Middle. I believe we should save the comment about industrial for the next meeting. That does leave open, there was one there was one recommendation about the R2 as it exists on Carlisle. And so do you want to talk about that?
So the staff completed an analysis for the parcels being affected by R2, the change from RO to R2. In this area, the only parcel that at the time didn't conform to the proposed changes was the funeral parlor. With the recommendation to have that as a special exception, now that would be a permitted use with special exception in the R2 district. One of the concerns with this area, and I had an opportunity to speak with college representatives today. For their properties, they do have a desire for commercial activities, mixed-use commercial. And they understand that it's probably not very feasible. I guess the Pizza House was the justification that was provided to me for why they don't expect to have the ability to do commercial in this location. Naturally, it is the Planning Commission's choice on this matter. We're recommending the R2, given the fact of the current built environment, the current uses that are existing, and the desire to maintain that, preserve that block environment.
Do you want to show us on the map, and then any Planning Commission members want to change this from The request is R2 to,
Well, there wasn't so much a request, it was just that was something that had been, Ms. Sipperly had brought up the comment regarding.
but the college, what did they particularly think?
Oh, they're fine with it as is. Oh, that was what was expressed to me earlier today.
I'm not hearing any recommendation.
I guess I sort of see the appeal of the possibility of like a cafe or something being in one of those big buildings on Carlisle Street. And that wouldn't be permitted if it was R2.
I think it would be.
It would be?
Yeah. Would it not?
I thought that would be like general commercial, I guess.
Oh, yeah, you're right, sorry.
So I do see the appeal of it maybe being neighborhood commercial or something that's allows, more limited commercial uses.
I do too, on neighborhood commercial, well, one of the three, maybe.
Yeah.
I would be concerned, I mean, if you think about the businesses that are along, particularly as you get more north along Carlisle, they are not walk-in businesses. They are the funeral home, right? You make appointments to go to the funeral home. You don't just walk in as a retail. It's not, there are very few businesses along there, with the exception of, I mean, I'm trying to think of any that are more of that like coffee shop vibe along Carlisle Street as you get further north like that, past Water, right? Because that's where I mean, Water is that kind of horizontal street there where we get into the red and the pink, but everything north of Water, that yellow, I mean, I'm struggling to think of currently a single kind of retail in that sense business that currently exists there. So to me, I think R2 conforms, particularly with allowing office uses, to what is existing.
The City Mart, I mean.
That's north of
That's
Water.
south of Water.
Well, it's just south.
It's in the revitalization district.
Ugly Mug is, well, no longer Ugly Mug, unfortunately, but like that building is south.
Okay, Marty or John, about this stretch of Carlisle?
Where?
No,
Mostly college properties. I mean,
Okay,
Oh, you said there
style.
could be. I thought you said there was.
Yeah, I want one.
so that means you wouldn't envision it as needing to be.
I think it's going to stay college, I'm pretty sure, right? Why would they sell?
I mean, it is a lot of college properties, a lot of college-affiliated properties.
Okay. Well, it doesn't sound like there's a lot of will, other than maybe Sarah and I, for making that change at the moment. So let's move on. Any objections to that? Then we are now at the place where John is going to give us an update on the process timeline, and then we will have announcements before final public comment. Not yet. Not yet. Please, if you just wait one.
Okay, so staff provided in the report just a general timeline. This would be assuming a December approval. What we're going to be doing, and this is something I discussed with the chair, actually having like a handout, a couple pages to better explain the changes that have occurred, what the map changes mean, things like that, kind of like an executive summary for the document. We'll get that together, provide these other information to the board, to the commission on the December 16th meeting. Maybe just bumping everything back by 1 month would make sense. So this would put us on a timeline for approval in March of 2025, assuming we would get then to a draft that Planning Commission is confident to vote on in January.
So, John, thank you for that. It seems to me that we have maybe 4 items and the map.
Yeah.
And also the executive summary.
Yeah.
So as soon as those things are finalized, perhaps in December, then a vote after that. I wouldn't think the commission would be ready to vote unless those things are already considered.
I'll call that the aggressive timeline.
Okay, all right, that sounds good. Unless there's an objection by the commission. Thank you. Our next Planning Commission meeting is scheduled in this room on December 16th at 7 p.m. The staff is continuing to work with the Gettysburg Station project applicants to complete a subdivision and land development plan application for the so-called Gettysburg Station property. Are there any comments from the Planning Commission? And now we'll do public comment, but if you, Ms. Castillo, if you could wait 1 minute, I believe there's someone behind you who's been waiting patiently to speak to an issue, and then we have more time now for public comment. Thank you.
Hello. Thank you for all you're doing. I know this is a large project, so I appreciate your service. My name's Allison Lintel. I'm a resident at 212 East Middle Street. My comment was in regards to the revitalization district and the, I believe you agreed to eliminate the density bonus and the incentives. Is that correct? Was that the recommendation? And the reason is I want to talk about the inclusionary zoning because I think with the deletion of the density goes away all of the incentives. And I wanted to make the comment that I think it would be valuable for the commission to consider, nevertheless, including some sort of inclusionary zoning in the overall ordinance, not just excluding or not just exclusive to the revitalization district, but perhaps when there's any sort of multifamily development, including if a church was converted to multifamily apartments, that a portion, 10 to 20% of those units would have to be affordable. I think that is, this is a real opportunity as you're changing the zoning ordinance, and many other municipalities have also implemented inclusionary zoning across all their districts, not just limited to the revitalization. So I'd hate to see that go away just because of the density bonus going away.
Thank you.
Mm-hmm.
Let's certainly add that for discussion. Others for public comment, please. Oh, wait, Ms. Castile, and then Mr. Smits.
Well, I don't live on West Middle Street or own a property there, so I don't have any money invested on that street. But I have a hard time seeing how Route 116, it's really Route 116, and it's a main traffic artery. There's constant traffic on 116 there. I have a hard time in my mind picturing that being a residential area, considering all the banks that are there, the shopping center that's there, and Kenny's, and it's a very busy traffic street. And it's a state highway, and I just wonder if that's, in my own mind, I'm thinking, is that really residential area or more of a commercial area?
Thank you.
I mean, already there's banks there, there's all kind of offices along there, there's Kenny's, there's that huge shopping center from across the church. So right across the church, you have the big shopping center. Yeah, so that's the only question in my mind. I thought, well, that seems, along a main state road like that with all that traffic, it seems a little unusual for me to think of that as residential somehow.
We'll note that. Thank you. Please.
The issues that the church raised were with respect to the disparate zoning of the Rite Aid and the High Street Brews properties compared to the church. All are in that section west of Franklin Street. And the question we had was, why was the church changed? It was originally residential, but then it was proposed to be commercial, and then it was moved back to residential, while Rite Aid and High Street Brews were not moved back to residential. The comment that a church is permitted in a residential area, in our opinion, is beside the point. If the only issue and the only justification for moving the church back to a residential classification is because it is a church, then we question whether that's a proper decision by the Planning Commission. The specific question we had was, what is the distinguishing characteristics and criteria by which you judged the Rite Aid and the High Street Brews property which are also in that same area, to be suitable for commercial, but not the church, which is in fact a non-residential public facility, much like those other institutions. It has a design, size, and scope, which is also typical of a commercial building. So we are looking for some rationale from the commission. What was the basis for that decision?
Okay, thank you. Are there further comments? Maybe first, anyone who hasn't spoken today and wants to speak now?
Hello, I'm Kayla. I live at 217 East Middle Street. I apologize if this is not very eloquent. I was invited to attend this meeting today, so I knew nothing about it. I had friends who had concerns about the definition of family. But that's not what I'm going to talk about right now. I just wanted to loft an idea. Everyone is going to get very used to me in this building over the next year, because I'm going to be campaigning for several things for the community. And one of those is more free third spaces. Third spaces are spaces where people can meet each other that are not their home first spaces or work second spaces. Many of these spaces are religious and not everyone is comfortable in churches. That is a free third space. The library is a free third space. Waldo's, because it's donation only, is essentially a free third space. I am going to be petitioning for more of those. And with hearing about the industrial area that they were talking about, green space on either side of where the tracks are, I would say in this moment that could be an opportunity for a free third space. And it just might be a nice thing to keep in mind as you do this process. You know more about it than me. As I said, I haven't been up to date. I'll get up to date. That's all.
Thank you. We have time for a few more, given the late hour. Separately, then Ms. Michaels, and then we'll adjourn.
I'm really kind of puzzled by this process. I guess it's a thought process, but on Carlisle Street, right now, there's a funeral home. You were concerned about having a motel, possibly revert to being a motel. B&Bs are allowed, and a number of other things like restaurants and things. So what you're doing by making those, first of all, the purpose statement for R2. Provide for the development of certain areas of the borough into residential neighborhoods that contain a mix of attached two-family and detached residential dwellings, and create walkable access to goods and services. The purpose of the NC2 district is to provide for offices, select businesses, residential uses, and other compatible uses within the historic mixed use, in this case Baltimore Street corridor, in a manner that respects and preserves the special character of the area. Adaptive reuses that preserve the viability of the larger structures within these areas are encouraged. That sounds just like Carlisle Street. You've got some huge buildings there that the college happens to own, but also somebody owns the one next to the funeral home. He's redone it. He's renting currently the top two stories to college students. The first floor is vacant. He happens to be the owner of Olivia's, and I've discussed with him the possibility of doing a cafe in there. Whether it will happen or not, but if he doesn't, if he's zone it to R2, a lot of opportunities could be lost there. Even doing something different with the motel building someday, which you were talking about. That could be small offices, it could be micro-unit residential, but if you take that sort of some low commercial away, nobody will be able to do anything except residential. And all the way north of Water Street. In the borough, there will be nothing except the vape store on Old Harrisburg Road, you know. So I just don't see in your thinking how, and then you took funeral home, motel, and B&B and stuck them into R2, where they don't meet the purpose. It just doesn't make sense to me. So I hope you will rethink that, because even the college, you said maybe the college would like to sell a motel someday. Well, maybe they'd like to sell one of their other buildings. Maybe there should be more opportunities. I think of zoning as an opportunity. A lot of people think of it as restricting, but you're doing away with opportunities on kind of a major street. And there's parents that come to the college. Be nice to have a place to eat. Or some of these, just because something's not there right now. In fact, that lamppost building on the corner of Stevens and Carlisle was a little restaurant. One of my neighbors waitressed there when she was growing up. Just because of who owns what right now doesn't mean in the future you'd want to have more opportunities. But I think it really, the adaptive reuse part of it and the larger structures, and a lot of those were built in the 1800s. So why take them out of that zone and put them into R2 where they don't fit? They don't fit the purpose.
Okay, thank you, Ms. Zipperly. I think one more comment, please, Ms. Michaels.
Sorry to keep you. I just forgot a couple things I wanted to ask about before you move away from this, from the NC areas.
We're not going to do Q&A right now, so just maybe if you do it as a comment.
Okay. So one of my concerns in looking at the Chapter 27 or Code of Ordinances is that the only real protection, it seems, for historic buildings is if they are on one of three registers, either the local county, the state, or the federal historic register. In order to get on those one of those registers, it doesn't have to do necessarily with the age of the building. There has to be something like historic that has happened at that building. Maybe somebody with historic significance has lived in that building, and it is a process that has to be undertaken usually by the owner and involves, some expense to do that. So in changing from Old Town to NC1, for instance, some of those buildings could be demolished in order to build another building there that would be maybe more cost effective, maybe better housing, but you would still lose that building. And a lot of buildings on that block are Civil War era, but just being Civil War era and present during the battle doesn't make them eligible for the historic register. So that's something to consider. And then when you look at what they would be replaced with, and maybe I'm wrong about this, John, I hope you'll tell me if I am wrong. It says that in Old Town there is a building height that should not exceed 48 feet. The same is not true in the NC1. And when there is a conflict, on page 164 of the Code of Ordinances, it says when there is a conflict between a use by right, and a building standard, that the use by right always wins out. So, as an example, you could have an inn of 20 rooms and parking in the NC1, which is a permitted use in the NC1. If somebody wanted to knock down the building that was there and put a parking lot and 20 rooms and common rooms on a piece of property, that would be a right that might well exceed 48 feet, and they would have a right to use, to that use. Now, maybe I'm looking at that wrong, I see some head shaking, so.
48.
But it is a question that I had in reading it.
Thank you very much. Can I have a motion to adjourn tonight's meeting?
I'll move to adjourn.
Is there a second?
Second.
It's Marty moved and John seconded. All those in favor, please say aye.
Aye.
And we stand adjourned at 9:58 PM. Thank you, everyone, for your comments and being here late.